morning, everyone. I'm Pragya Shukla, a trustee at Hourglass, and I'm delighted to welcome you all to our webinar on the lasting power of attorney, informed decision making. Before we dive into our discussion, a few housekeeping notes. This webinar is being recorded and will be sent to all those who have registered with us. This recording will also be available on our knowledge bank, and we'll share the link in our newsletter and on social media. Now let's make this a truly interactive experience. I encourage all our delegates to sign up for our newsletter, follow us on social media, and actively engage by sharing and commenting on our post. Your participation is the key to building a very supportive community. Shortly after this webinar, you'll receive a very short survey via SurveyMonkey. We highly value your feedback, so please take a moment to share your thoughts. Your inputs help us improve and tailor future events to your needs. Now, today's discussion's backdrop is a matter of great concern. Calls to Hourglass helpline regarding financial and economic abuse have been steadily increasing. Surprisingly, our 2020 polling revealed that a significant portion of respondents in UK did not perceive the misuse of power of attorney for personal financial gain or attempts to change an older person's will as abuse. This webinar aims to shed light on the features of power of attorney, emphasizing the benefits and risks involved. Moreover, it serves as a platform to discuss how various sectors can collaborate to overcome challenges in information sharing. Today is a privilege as we welcome distinguished experts from Anthony Gold, a leading multi-law firm with national reputation for excellence. Their standout quality isn't just legal, but an unwavering commitment to assisting the vulnerable. Anthony Gold proudly serves as the London founding partner of Hourglass Given Our scheme, providing pro bono legal advice for complex cases. They're here to guide us through the prowess of power of attorney in tracing details and its crucial role in addressing financial and economic abuse. I would now like to introduce our panelist, David Wedgwood, a luminary in the legal field with over 2 decades of experience. David, could you please introduce yourself?
Good morning. Yes, I'm David Wedgwood. I'm a partner in charge of the Corporate Protection and Litigation Department at Anthony Gold, and we have a lot of experience in dealing with powers of attorney, deputyships, challenges against them, and also recovering assets from fraud or misuse. Good morning.
Thank you, David. I would now request Kimberly to please introduce herself.
Thank you. Good morning. I am an associate solicitor in the civil litigation team at Anthony Gold. I specialise in contentious trust and probate litigation, and I have experience in contentious court of protection matters. Prior to working at Anthony Gold, I worked on a range of non-contentious and contentious private client matters, which included assisting clients in putting lasting powers of attorney in place. Thank you.
Thank you, Kimberly. I would also like to welcome Lord Hunt. Lord Hunt is an esteemed veteran for Hourglass since 2022. He's a distinguished member of House of Lords and has played significant role in public services. Can you please introduce yourself, Lord Hunt?
Thank you very much, Chair, and good morning, everyone. Unlike other panelists, I make no claim to be an expert, but I am a strong supporter of Hourglass, and I've spent quite a long time in the Lords and raised issues in relation to abuse of older people. I'm particularly interested in power of attorney, both through personal experience, but also because of the potential abuses to older people that can arise from them. So although I'm a panelist, I'm learning really as well. Thank you.
Thank you, Lorden. I would now shift to Lucy Welsh, who is also our helpline team leader at Hourglass. Lucy, can you please introduce?
Hello there. Thank you. Good morning. So my name's Lucy Welsh. I work here at Hourglass. I'm the helpline team leader. I've been with the organisation since March 2022. Previously to working to Hourglass, I've spent many years working in the charity sector in various different positions, mostly in advocacy and statutory advocacy, so supporting people under the Mental Capacity Act and the Mental Health Act and under DOLS. legislation. So that was kind of before I joined Hourglass, and now I'm here at Hourglass. I manage the helpline team, so small team, taking calls, taking emails, taking instant messages on all manner of different topics. So yeah, that's me.
Thank you, Lucy. And now let's shine a spotlight on Nick Kelly, our External Affairs and Parliamentary Manager at Hourglass. Nick, can you please introduce yourself?
Hi, well, I'm Nick, and my key focus is on legislation and on lobbying, as well as a sort of public engagement. The issue of powers of attorney has been on the sort of burner for a while. We know it's something that's comes up fairly regularly as an issue, and it's about getting that balance right and trying to make sure that we've got safeguards in place.
Thank you, Nick. So before we delve into our discussion, a quick note that the content of today's webinar pertains to practices and laws in England only. So without further ado, let's explore the lasting power of attorney together. Lucy, if you could please start with the cases.
So I've got a number of cases to talk about today, just some general cases, the quite typical inquiries that we get in that coming into the helpline. So the first one is where the caller's mum was in a care home, and the local authority had said that the caller, who was last in power of attorney for his mum for finances, needed to sell her property in order to pay for the care home fees. But the complicated issue here was that the mother's property, along with a number of other residents' properties, were being allegedly scammed by somebody who we'll call AC. He was a company manager and had recently gone to a tribunal. And when they were at the tribunal, the residents and the family members thought that he'd given the judge some false statements. So basically, the caller got in touch with us because she was really affected. Her mental health was really suffering, and she no longer wanted to be last in power of attorney for her mum. She wanted to step back so the local authority could resolve this issue and then, carry on with selling mum's property. So a number of actions that the caller had already taken were they'd contacted the local authority's financial assessment team, they'd contacted a solicitor but found that the legal fees were too costly, they'd contacted their local MP in order to raise a complaint, and they'd reported the alleged perpetrator, AC, to the police, but the police kind of came back and said, they're not trained on property crime, so we're unable to investigate further. So that's the first scenario that we've got. Thank you.
Perhaps I can lead on this one, as we do quite a lot of work around fraud and recovery of assets from fraud, which is now a very major problem in the UK. I read yesterday in the papers that in the first 6 months of this year, over £1 billion was lost to fraud. Most of that, or a lot of that, would have been elderly people who've amassed capital through their hard work and are now vulnerable to fraudsters. And although it's not quite clear in this case what type of fraud this is, there's a vast range of frauds, Ponzi schemes and carousel frauds, cross-firing frauds, the mis-selling frauds. But what is clear is that Mother was vulnerable. It's not clear whether Mother actually has capacity in this scenario, and you must always start with whether the protected person or vulnerable person has capacity, and whether she was actually assigned something away in this case. However, what this case does illustrate is that most people with a lasting power of attorney, the attorneys themselves, are taking on a very big responsibility, and particularly when things get complicated, and they're doing that with very little support. And I think this case clearly illustrates that they went to the police, they went to the local authorities, and they got very little support there. And so in this case, the attorney who is doing their best is looking to renounce. In this particular case, I think there will be some problems renouncing, because effectively, if you do renounce, that does lead to a long period when there's no one at all there to represent the protected party. And this lady is doing her best for her mother, but I think really, rather than her renounce, which might lead to a period of 6 months or a year when no one is there, she perhaps should be looking to get some more support. In terms of the in terms of the local authority, they do have a statutory duty to consider deferring fees of care homes. And this is something that you would want to refer to safeguarding and to social services to look at. However, I personally have found that local authorities are quite reluctant to take deputyships, as they can do, in cases where there's complicated potential litigation around. In this particular case, in fact, before I talk about what might be done to recover the assets, I'd like to talk a little bit about prevention of fraud, in particular with people who have lasting powers of attorney. If you have a deputyship, then you're in fact you're duty bound to register that deputyship with the land registry, and a restriction is placed on the title which prevents anyone from dealing with the land. And this does seem to be a land fraud here, without with the deputy's permission. That restriction isn't available for lasting powers of attorney. However, it is possible for the lasting power of attorney to apply to the land registry and ask for them to be notified of anything happening with the property, and their name and address is registered. So if any transaction or charge or mortgage is taken against the property, they are first warned of that and can intervene. In this case, it seems a little bit too late, and there has been a fraud. The problem with frauds is that most of the time the fraudster is quite sophisticated and will use a false name and disappear. That doesn't seem to be the case here, in that it seems as if the person is known. What I would recommend in this case is that someone seeks tries to get free legal advice, and here they came to Hourglass. And perhaps this was before we came in as a founder member at Anthony Gold, but this is a sort of case where we would happily give some a free assessment as to whether we could look to act for the lasting power of attorney in recovering these assets, perhaps on a no-win, no-fee arrangement. The other way of the attorney proceeding would be to perhaps apply to either the local authority or to the Court of Protection for a new deputy to be appointed. It's not clear whether in this case Mother has got capacity, and perhaps she could just sign another lasting power of attorney and appoint a lasting power of attorney, but I'm assuming that she doesn't. In that scenario, then the attorney would want to apply to the either to the local authority, and as I said, they may not want to take it on because of the complexity, or to the Court of Protection. At the Court of Protection, the court may well appoint a panel deputy, or may seek to involve the official solicitor and ask them to act as litigation friend in recovering the assets from the fraud, if that is a possibility. The official solicitor tends to go to one of their chosen solicitors and get them to assess it. In fact, we happen to be their chosen solicitor in London, and then we would assess the case. However, the official solicitor will only take a case on if there's funding for it, which means if there is either a bank account, or whether their solicitor will sign up for a no-win, no-fee and seek to recover the assets at the end of the day, their costs at the end of the day. So it is this is a particularly complex case, but as I said, it does underline the fact that taking a lasting power of attorney is a very big responsibility, one that most people, and normally it's a child of the protected party, take very seriously, but often people don't have the guidance and support to deal with very complex situations that might arise. Thank you. I hope that's helpful.
I've got a couple of points to add that the caller could maybe think about doing. If, obviously if the scam involves money leaving the elderly or the vulnerable person's bank account, then that bank could be contacted and asked to freeze the account. and the bank's fraud team could also provide assistance to the caller. Another thing that the caller could think about doing is maybe check the elderly person's credit score to see if there's been any changes that might suggest suspicious activity. And you know, if that's if they suspect that there might be some other kind of fraud going on. But yes, thank you.
Could I just ask fellow panelists, really? I mean, two things arise for me. First of all, the inaction of the police. Is this a typical reaction of all police forces? Do we have examples of police forces who have been prepared to intervene? Does there need to be more discussion with police chiefs on this? And of course, one would relate this to some of the issues around dealing with fraud in general. The other issue, which has struck me, having been power of attorney both over a cousin and my mother, is this lack of support for people who take on this responsibility, or I would suggest even an understanding of what it is they're taking on. Is there more, do you think, that we ought to be doing collectively, government, society, to actually prepare people for what's clearly can be sometimes a very challenging situation to find yourself in?
May I just comment on the first point? Yes, the police are massively overwhelmed with fraud and particularly complex fraud. We had a case quite recently where the police actually knew where who was doing it and where they were, but in fact they were living in Dubai, so they weren't able to extradite them. But having had conversations with the police, they are massively understaffed in this area, and this is complex work. So it, in fact, although it is true to say that there's different divisions within the police, and some are more set up to deal with this type of fraud, particularly in the City of London, they are massively under-resourced, and I've had frank conversations with them around that. So yes, it is a real problem of resourcing, I'm afraid. On the other issue around support, it is possible the OPG, who are the Office of the Public Guardian, who are responsible for the supervision of lasting powers of attorney, do have a helpline, and they can be contacted and an email, but they're firstly they're quite low profile, and secondly their support is quite limited. They tend to signpost you to social services often, but there isn't enough literature around lasting powers of attorney, particularly as it's getting easier and easier to get them. And people are getting them because for all the right reasons often, but not knowing their responsibilities. Thank you.
So I recently spoke at the Metropolitan Police event, and that was talking about abuse generally, and we talked quite a lot about economic abuse, and they were the first to admit that they need to learn more about how to deal with this, but they were open to learning. I think it's definitely, from what we've seen, has been varying from police force to police force as to how much seriously they take it, and often do they have the experience and skills to actually address it. In terms of the Office of Public Guardian, yeah, we've been working with them as well about some of the changes to the LPA process. And I think they're getting there, but I think they too are a bit slow to sort of see the seriousness of some of the fraud that's potentially happening.
Thank you, David. Thank you, Nick. Thank you, Kimberly. Thank you, Lord Hunt. Lucia, can we have the second case, please?
Yeah, certainly. So this came in from a caller who was concerned about their aunt. So their aunt is 80 years old and had recently been diagnosed with early stage dementia. She'd moved into a private care home on the advice of social services for respite, a respite period of 6 months. But 6 months later, she's still there, and there's kind of no discussions around her moving on. The caller had concerns that her brother, who had instigated the social services involvement, had been abusing his aunt emotionally, physically, and financially. He'd had control of her bank accounts for some years, and it would appear that the caller had found that there was significant monies missing from the aunt's bank account, and that had been paid to him, to the brother, and some other family members that were closely related to him. So the aunt had confided in the caller and other members of the family that on several occasions when her brother arrived at the property where she lived alone, she did actually hide herself away from him because she was quite scared of him. She was afraid of answering the door to him. So the brother had applied for lasting power of attorney jointly together with the caller's mum. And the caller is considering appealing his application for lasting power of attorney, but he doesn't want to obstruct or delay the applicant, the other applicant, who is the mum. So especially as the aunt has now moved out of the private care home into council-run care by social services, because her aunt's funds are not available until the local authority approval. So, hence I think that's what David touched on earlier on about, delays and what have you, and the impact that has on. So that was quite a big factor in this case.
Thank you. I'll maybe start off. It's not clear from the case study if the caller was one of the persons to be notified of the LPA, or whether they actually found out about the LPA through their mother, who's been appointed as an attorney. But if they were to be one of the persons to be notified, there's a form that needs to be completed, which is the LP3 form. And that is then sent off to the OPG. And on that LP3 form, it lists the reasons for objecting to an LPA. And one of those reasons is that there was fraud, or the donor was pressured into making the LPA. So as it's a specific attorney that's being objected to, the OPG's guidance is actually that this wouldn't prevent the registration of the mother as being appointed as attorney. So the caller doesn't need to worry about it, delaying that being registered. But as I said, if they are one of the persons to be notified in the LPA, then they should fill out that form, and they should let the OPG know that they do have concerns about the brother. Yes, so I think if anyone were to believe that the attorneys were not acting in the donor's best interests after the LPA was registered, then again, those concerns should be raised with the OPG. So either way, the OPG should be notified of the concerns.
Perhaps I can say a few words as well. Presumably here the aunt does have capacity, although she has early stage dementia. She has capacity to enter into a lasting power of attorney. We know that because one's just been applied for. And it is important to put the vulnerable person at the center of things, because if she has capacity to enter into a lasting power of attorney now, she also has capacity to revoke a lasting power of attorney and perhaps set up a new lasting power of attorney. So the problem with going into the OPG's complaint process is that can literally take several years if there's any sort of complexity. And often it is easier to go to the person themselves and have a conversation and see what their view is, because that also is quite central to what might happen. The lasting power of attorney is joint, and I presume it's not joint in several, but as such, there is some protection there anyway, because mother will have to deal with certainly things like selling a property, and she'll have to consent, although we're not told about the relationship between mother and brother in this scenario, and whether perhaps brother is slightly overbearing on mother as well. But that is something clearly she'd want to discuss with her mother as well. I know that she's been put in respite care and she's been there 6 months, and we do see this happening where someone goes into respite care, deteriorates, and then they remain there. There should have been the local authority should have done a dole's application in that scenario. That's a deprivation of liberty application. And at that point, family members can intervene, although that's slightly different from the lasting power of attorney issue. The fraud in the past, or the again, that needs to be looked at. It may because aunt had capacity, it may be that aunt gifted these monies, rightly or wrongly, to brother. Perhaps he gave her a sob story and she gifted the money. If she had capacity to do that, then she's perfectly entitled to do that. So you have to take it with a bit of pinch of salt around substantial monies going missing if the person has capacity. And again, before you started objecting to a lasting power of attorney, you would want to speak to the aunt, and I mean, she might say, "Oh yes, I gave that to him because, you know, he needed a new car," or something like that. So you should definitely kind of look before you leap in this sort of scenario. But this is the different kind of scenario where the abuser or the fraudster isn't an external person, but is within the family, and then you've got to think about family dynamics and the person's capacity and what their views are. So it can often be more complex, not so legal, but you'd want the person to consider all those sort of issues. So I hope that's been helpful.
Thank you, David. Thank you, Kimberly. I'm sure that has been helpful. Lucy, if there's another case that you would like to share with the panelist.
Yeah, so this is our third and final scenario. It's a little bit more around dynamics, family dynamics, which is kind of what we get a lot of on the helpline, where kind of family members aren't getting on. So it was Bob who contacted us. He contacted a number of different agencies and just didn't feel like he was getting anywhere. And he was suspecting that his mum is being coercively controlled by his sister. So his mum's 86 years old, and he was recently told by his sister that she no longer wants to have any contact with Bob. And also that had been reiterated from the agencies that he'd contacted. So his mother has capacity to make decisions around her relationships, who she wants to spend time with. So the agencies had kind of relayed that there was nothing they could do. She was perfectly, capable of making those decisions for herself. And that there was nothing they could do to kind of help in this situation. So his sister had both types of lasting power of attorney for the mum, so both health and welfare and finance and property. Bob was quite shocked by this development, that he wasn't kind of involved, because when he visited his mum earlier that year, she seemed absolutely fine with him. So Bob had at one point distanced himself from the family, but he hadn't fallen out with anyone. When he kind of called the helpline, he was very frustrated that when he contacts agencies, they're just not getting back to him. They're not getting in touch with him. They're not kind of giving him updates. He tried to contact social services, but they couldn't provide him with an email address, so he couldn't get hold of the specific caseworker. He'd also visited the police and kind of spoke to the police about his concerns, and they did go around and visit his mum. But actually, when they got there, the sister was also present, and she was in the room for the whole time. So, and since Bob suspects his mum of coercively controlling suspects his sister of coercively controlling his mum, he was very disappointed that they didn't, try and speak to his mum, alone. Bob's tried to contact his sister a number of times to discuss this situation. She doesn't answer. She doesn't call him back. She refuses to get in touch. Bob only had like a landline number, so he was unable to get in touch with her. He was unable to send messages. So yeah, he kind of phoned us up with this situation and was understandably frustrated by it. Thank you.
Thanks. Yeah, that is a very difficult situation that Bob is in. As I mentioned before, Bob should contact the OPG and flag his concerns. As David said, it can obviously take a long time for the OPG to look into it, but it's definitely worthwhile doing. In terms of the father, Bob should look into this further. If evidence can be gathered to show that the father's care was not satisfactory, then this could be used as evidence as to why the sister should not continue to act for the mother. Yeah.
Yeah, I agree. I think I mean, in some cases, my father's personal representative of his will might be able to take some action and make some inquiries. I think it is always very difficult when you have a situation where someone has capacity, or perhaps they have borderline capacity, or perhaps one person thinks they have capacity and the other person doesn't, to have a proper assessment of their capacity, particularly if the protected party isn't forthcoming and isn't prepared to engage with a capacity assessment. And the test for capacity, particularly around lasting powers of attorney, is quite a complex one. Within each lasting power of attorney, there has to be someone, a certificate provider, someone who will certify that the person has mental capacity to enter into that lasting power of attorney. The rules at the present, though, are quite wide as who can do that. It can just be a neighbor, and so it doesn't have to be someone with medical experience, or in particular medical experience as to that person's condition. And it is a complex thing to do, and I'd be very surprised if the police actually went round and did do a complex mental capacity assessment. And we have scenarios. In fact, I was in court last week in a scenario where 4 doctors had said someone did have mental capacity, and the Court of Protection appointed, through the Office of the Public Guardian, appointed a special visitor who's a government-paid psychiatrist who went round and visited the person and looked at their medical records, did a detailed and complex assessment of capacity, and found that he didn't have capacity. And the Court of Protection went with the special visitor's report, primarily because the other 4 medics weren't psychiatrists, and although they have some experience of dealing with mental capacity, they didn't have experience of dealing with his particular mental capacity issue, which was a brain injury, and they didn't have particular experience of dealing with the test for capacity for that particular decision, because capacity is decision specific, as we call it in the profession, which means that you may have capacity to do one thing, and many people do have capacity to do their shopping or whatever, but you might not have capacity to do other more complex things, such as make an investment or sell your property or various other things. And the same applies for welfare lasting powers of attorney, where again people can be appointed a welfare lasting power of attorney on just the certification of a neighbor. So the test for capacity to make a lasting power of attorney, and I'm cribbing from Kim's memo to me here, is that well, under the Mental Capacity Act, there's a 2-stage test, which is essentially one has to show that someone has some impairment of their mind that might impact on their capacity to make a decision. In this particular scenario, we're not given the exact details, although it does seem as if mother is quite elderly. So it may be that she does have perhaps early onset dementia or some other problem. But if you have that kind of diagnostic stage ticked off, you then have to show that their impairment actually impinges on their function, and that's their function to understand the information relevant to a decision, to retain that information and to use and weigh that information as part of the process of making the decision, and then whether to communicate that decision. So it's quite a complex test, and there's been a lot of case law around whether someone had capacity to enter into a lasting power of attorney. There's a recent case involving the Public Guardian and our and another person. And that's the Court of Protection then held that the donor has to be able to understand, retain, use, and weigh up the information relevant to the effect of the lasting power of attorney. And so that can be quite wide-ranging. And I think a lot of people, a lot of lay people have perfect capacity, don't understand what you can do with a lasting power of attorney. You can basically take over that person's finances and to some extent their welfare. And they have to be able to understand who the attorneys were, and they have to understand the scope of the attorney's powers, and also the scope of the assets that the attorneys might deal with. And then they have to then weigh up the pros and cons of entering into that lasting power of attorney with that particular person. And that means being able to assess that person's personality and what they might do. So it is quite a complex test. If someone isn't going to engage with social services or the police, it is quite difficult to actually to get a independent capacity report. You'd have to gather a lot of information and evidence around they have to gather a lot of information around what's happened and your concerns. It is possible in some scenarios to go to the Court of Protection and say, I have all these concerns. I suspect they don't have capacity, and the Court of Protection will order a special visitor to attend, although that is quite a rare scenario. So, but it's something that one might consider. So I agree with Kim here as well that that it is worth keeping on reporting matters to the OPG and to the social services as they arise, and keeping a kind of paper trail of what's happened, because later on that may be very useful. But at the end of the day, if mother does have capacity, unfortunately, she is empowered to do as what seems to be happened here, because people are allowed to cut people out of their lives, perhaps capriciously, perhaps for all the wrong reasons. But as long as they're doing it with capacity, then to some extent the authorities' hands are tied. There is a kind of a jurisdiction within the family courts for vulnerable people and to protect vulnerable people, but essentially, if you're going to the Court of Protection, you do need to start with establishing whether whether that person does have mental capacity, and that can be difficult if the person isn't cooperating, as I said. So I'm afraid not a simple. I have no simple solutions, I'm afraid, for this scenario, but it is a scenario that does happen quite often, and is obviously a great concern to people. So I hope that's been helpful.
I've got maybe one more thing to add to it, and it's slightly moving away from LPAs. But in situations like these, where you have a family member who is suspicious of someone unduly influencing the donor being the person that set up the lasting power of attorney, it is important to consider whether the donor might also have been influenced into changing their testamentary disposition. So that would be a will. And in this scenario, it would be a will being made in favour of the sister disinheriting Bob. And obviously that would only likely come to light after the donor has passed away, but it is something to bear in mind.
Thank you, Kim. I do see we've had some questions from the webinar chat, and please do put your questions in. If I may take the first one from Mark Stewart, where I ran through the Mental Capacity Act test in the order set out in the Act, and Mark has said that that there's been a recent High Court case that ruled that that the order of assessment of capacity, i.e., first of all, establishing that there's a disorder of the mind that might impair decision making, and then the stage, and then the functional test, and the four categories of functional test has been reversed, and there in that case the court looked at whether the person was functioning first, and then looked at their disorder, whether they had a disorder. And that is something that we come across as a growing trend, and it's in a lot of cases perhaps it's not so significant, but in borderline cases it can be significant, in that the court are more and more now looking at whether this person is functioning properly, and whether what they're doing is capacitous, i.e., whether what they're doing is something that is reasonable and sensible and in line with their historic kind of preferences, and then looking at whether they're disorder of the mind, and that's a growing trend in psychiatry as well, in that more and more people are not diagnosing, as it were, some mental illness or mental problem, but they are looking more at the functional tests. And more we get people who are being described as having some disorder, personality disorder, rather than being diagnosed as being having a mental illness. For example, schizophrenia. Now, people tend to call it a schizoaffective disorder. So there are changes in the way that the courts are looking at it, as there are changes in psychiatry. But the Act itself is quite clear in that you have to actually have a mental illness or mental disorder, and then you have to show that there's a lack of function. But in practice, they tend to go hand in hand, because if someone is behaving very strangely, then there normally is some form of disorder, and the court won't in a way, they won't tie their hands, because no one's actually come up with a formal diagnosis. So they will they'll take a broader view, and I think that must be the correct way of doing it. So that's the first question. Shall I take the second question as well, or does anyone else want to jump in?
I don't mind. I'll read it out, and then I'll give my take on it, and then I'll let the others chip in. So the second question is, what happens when a former working alcoholic mother has signed an LPA under semi-secret duress from a younger brother, then she revokes it when it is discovered, but then gets a visit from the council on request from the younger brother to ask whether she was fully aware of what she had done? The younger brother then withdraws most contact and restricts grandchildren visits. A year's stalemate continues. The mother is torn, currently no LPA at all. So in this situation, I would suggest that the caller contacts the local authority and raises a safeguarding concern. And there's obviously no LPA in place, so the OPG can't be contacted. So a safeguarding concern should be definitely raised with the local authority.
Yeah, may I jump in as well? In fact, we have a case very similar to this at the moment, or several, I think, because I discussed how to enter into an LPA requires mental capacity. Well, it's also the case that to revoke your LPA requires mental capacity, and very similar criteria apply. And so if someone has an LPA and it's revoked, they have the opportunity to contest that, and they often do. And often, there's a complex family dynamic behind the scenes, often between two children, and the mother who's often in the middle and feeling kind of, even if she isn't being abused, it's a very difficult position to be in, as you can imagine, and wanting to keep everyone happy. And then she signs a new LPA, and the other person then objects. So in that scenario, what often happens, and it again, it can take a long time for anything to happen with the OPG, but if the OPG see that that an LPA has been objected to, or a revocation has been objected to, they will then start a process of investigating themselves. That can take a very long time, sometimes years, as I said, and then in the end you can end up in the Court of Protection, and the Court of Protection might then appoint a special visitor to go around, or there might be some NHS doctor who can prepare a report. The difficulty is in those scenarios, particularly if you have someone with a declining condition like Alzheimer's, by the time it's got to court in 2 years' time, they do, whether they did or they didn't have capacity at the time is perhaps irrelevant, because they lack capacity by the time the special visitor comes round. And so you can end up in a situation where you have this exact hiatus of no one being able to do some often very important decision making. And in one of the scenarios, it was mentioned that someone was forced to move from their private care home into a local authority care home, which I have to say is quite unusual, because normally private homes will convert them into local authority homes. They tend to move them to a local authority. They tend not to like to do that, because they have to receive a lot less in terms of their rent and care fees. But so it is not very it's not a very good idea to be left in a scenario where you have no one dealing with it. In that case, I think what I would recommend to a lasting power of attorney who's trying to protect someone is to make their own application to the Court of Protection, perhaps to set up an interim deputy who can hold the fort whilst the decision as to who the lasting power of attorney can be, and that would be normally a professional deputy. I mean, I'm deputy for about 100 cases, and my wide team, or it might be a panel deputy. The difficulty, to do that though, you do have to get initially a declaration around capacity and whether they have capacity at that time, and obviously a deputy can only step in if the person lacks capacity. So yes, that can be it can be a problem if you don't have that capacity report. So so thank you for that question. I hope that's been helpful.
Thank you, David and Kimberly. So we have a few more questions. We recently did an Hourglass poll where 1 out of 3, that is, approximately 34% of the people said that using a power of attorney for personal financial gain was not an abuse. What, in your experience, is the rationale behind individuals taking money from vulnerable people? I would open this question to the panelist.
Sorry, I don't want to hog the limelight, but from my experience, I mean, there are some people who are just plain bad, but I think a lot of people take the view that that the protected party, especially if it's a vulnerable elderly person, it's family money and it's their inheritance, and that's a very selfish perspective, and it's certainly not one that the courts apply. And the courts deem it almost irrelevant whether you're next in line for inheritance. And there's very firm guidelines with the court around what gifts an attorney or a deputy can make, and they are small gifts on special occasions like birthdays or Christmases. And there's been some guidance that they should normally, over a course of a year, not amount to more than £3,000, although that's very rough and ready. So it is family members possibly living in the house and perhaps caring for the person, viewing it is their home, their house, family money, and that is where some problems can arise. But as I said, although one can perhaps see how people might think like that, that certainly isn't the case. The way the law looks at it, and the way the courts will look at it, and the way the OPG will look at it, if any issues come before them. So,
I think there's probably there's more that we can do in legislation to sort of help encourage behaviors. So, I know in the U.S. states of Washington and California, the forfeiture legislation actually prevents people who've committed this sort of economic abuse from then inheriting. In the UK, there's the Forfeiture Act 1982, but that's, I believe, applies when the person has been killed. It doesn't apply if there's just been, economic abuse while the person's alive. So it feels like there's more room in that way to sort of encourage better behavior, or at least use the law as a disincentive for this.
Can I ask you on that, Nick? Because clearly one of the values of today, apart from listening to experts advise on some very difficult cases, is can we change practice, procedure and law? We have King's Speech coming on November 7th when the government sets out its legislative programme for the next year. Are there any prospects of any legislation we could use or we think might be coming in the coming session to highlight this?
The obvious ones, of course, the Victims and Prisoners Bill. And there are, sort of a broader sense, there's going to be definitely a push for specialist support services, the specialist advisors to support older people is something we really want to encourage. Where we have had them, they've been really good. And that's for all forms of abuse, but we know that economic abuse is the most prevalent. That's reported to us. So that's really the logical one. But we've also started working with the Home Office Fraud Task Force. So that's not legislation, but we are sort of wanting to work with them. We've also got the banking sector involved and the finance sector. And in time, there may be some policy recommendations out of that work as well, although that's probably after a coming election. The other thing, of course, is that the parties are all looking at manifestos at this point, so trying to sort of make sure that's highlighted, because economic abuse and economic crime is becoming, and fraud are becoming a much, much bigger issue across society, and making sure that we highlight that older people are often the most vulnerable.
It's very noticeable, in the discussions we do have about economic crime, you have to keep piping up and say, don't forget the impact this is having on older people. So it's a constant battle, isn't it, to raise awareness. But I think we ought to have a discussion post King's Speech rather, just to see if there are opportunities, because even if legislation is not necessarily will not necessarily get through, at least raising it in preparation for post-election legislation would be a good idea, I think.
Absolutely, yeah, agreed.
Sorry. I'm sorry, I'm just cautious of the time, so moving on to another set of questions. So we have been talking about power of attorney and deputyships. What is the difference between the two, and which one has more protection? I was just wondering if we can understand the difference.
Yeah, perhaps I can take that. I'm a professional deputy, so I'm up to speed with the duties. A deputy is appointed once someone has lost capacity and doesn't have the capacity to enter into a lasting power of attorney. So that's the kind of primary difference between them. They're appointed by a court order rather than by the deed, which is the power of attorney deed. Their regulation is much more controlled. They have a duty to report annually to the OPG and provide accounts as to expenditure. There's a very detailed kind of guidelines as to what they can and cannot do, and they are quite closely monitored by the OPG. There's also a significant difference in that with deputyships, then every deputy who enters into a deputyship has to pay for a bond. This bond is basically an insurance policy that covers the protected party from any wrongdoing. So if the deputy runs off with the money, then the protected party or the relatives of the protected party can claim on the insurance policy. That applies to lay deputies. Most deputyships, 95% probably, are not professional deputies. They are children of the elderly person often, and it does give you some sort of comfort around that. Obviously, if you have a professional, then they'll have their own insurance anyway. The downside of a deputyship is that it costs more money. Certainly, a professional deputyship will cost a significant amount of money. The fees of a professional deputy, who's normally a lawyer, are assessed by the Supreme Court's office, and they will make sure that those costs are reasonable, but they will be paying the fees at a prescribed rate, which is I think it's £200 an hour, or depending on the area that the deputy's in. And so you can see if the deputy does quite a lot of work, it's quite easy for the deputyship solicitors' fees to go up to £5,000–10,000. I mean, in some cases they can be really, really high where you have very complex situations. So that's the difference. I mean, a lasting power of attorney is also much easier to enter into, and in fact you can do it online, and it is quite a straightforward way of dealing with things, and for a lot of cases that is the best way. And I think lasting powers of attorney outnumber deputyships by about 50 to 1. There are far more lasting powers of attorney around. Often many of them are never used, but and are used perfectly correctly. And there is this dichotomy from the policymakers as to wanting to enable family to deal with people's assets and to make sure that they're well cared for and represented, and for that to be a simple process, as against protection from abuse. So that's where deputyships have a lot more protection, and I think some people are arguing that lasting powers of attorney should have some of the protections that deputyships do have, but against that you have to factor in that there will inevitably be an additional cost in terms of insurance policies or OPG fees or court fees. So I hope that's helpful.
I'll just add another difference between the two is the fact that with an LPA, the donor gets to choose who acts as the attorneys, whereas with a deputyship, they wouldn't get the chance to choose. And then another difference would be the length of time that it takes to put them in place. David did mention the fact that it's more complex to get a deputyship put in place, and that's reflected in the amount of time as well that it takes. And an LPA takes around 2 to 3 months from when it's prepared to when it's registered by the OPG, whereas an application for a deputyship could take around 6 months to put in place. So that's another important difference between the two.
Can I ask a question on that? So with the deputyship, because I know with LPAs, there's issues around not necessarily having to tell family members that they've taken one out. What happens with the deputyship? The family members get told that has to be in place, or that's in place.
Yes, there's a notification process, and the guidelines are that all family members should be notified. There may be some exceptions, and you can apply for an exemption if someone is abusive or something. But yes, that's right, and often social services are notified as well. So there's a full notification process.
Thank you, David. Thank you, Kimberly. So the question we have is, can a person change their mind after creating a power of attorney to revoke or cancel it, or change it to another power of attorney? What are the challenges if they are planning to do so? And can an attorney refuse to change a power of attorney?
Yeah, I think we touched on this earlier, and yes, it's all about capacity. And if you've capacity, you can make many lasting powers of attorney. But at every decision, the capacity can be challenged, and certainly there's a requirement that the outgoing attorney must be notified, and the outgoing attorney will have the right to challenge a revocation on the basis that that person was unduly influenced or perhaps lacked capacity to revoke. So the answer is yes, you can do that.
And building upon that question, can the acts of an attorney be challenged after the donor's death?
Do you want to take this, Kim?
Yes, sure. Yes, the acts can be challenged after death. Particularly if there's money involved, then that could be investigated and looked into. And, if money has been improperly taken, then you could look to try and get that paid back into the donor's estate.
Thank you, Kimberly. Another question we have is regarding joint versus joint and several power of attorney. When and how far do attorneys have to agree or cooperate when it comes to joint versus joint and several power of attorney?
Yeah, I mean, going back to Kim's question, the person who could challenge someone after death would be the administrator or the executor of the will, and so you then get into the whole issue around contentious probate and who should be the executor and whether you should replace an executor. So it can be quite complex, that whole process. But on joint powers of attorney, the lasting powers of attorney are very much governed by what's written on the deed itself, and if the deed says joint, then pretty much everything has to be done jointly. If it says joint and severally, then the attorneys can do pretty much everything on their own. If you're looking at transferring a property and they're both registered, then a conveyancer should get both of them to agree to sign the transfer deed. But pretty much everything else can be done individually if it's a joint and several. And this does go to the issue about how a lasting power of attorney should be drafted, because most lasting powers of attorney aren't drafted by solicitors. Very few of them are. A lot of them are done, directly or online, and people just tick the box, joint and several. But you can put within there restrictions on attorneys, and for example, you could say that attorneys can act independently and severally for decisions of up to £1,000 or something like that. And that's normally quite helpful if you've got one person who's kind of on the ground and someone far away, but you want some sort of oversight. You can make it 10,000 or whatever the value you wish, depending on the particular case. And you can also, on these powers of attorney, say that you want the lasting power of attorney to only kick in and when that person has lost mental capacity, and you can put your own kind of restrictions on how that works. That again can be useful, because you have to remember, with lasting powers of attorney, as soon as they're registered, someone can sell your house, take all your money, or speculate or invest and do whatever they want. So sometimes you would want to restrict the attorney by the deed itself, which is the document and what's written there, and kind of put down instructions. And the same applies for welfare powers of attorney as well.
Thank you, David. Thank you, Kimberly. So there's another anonymous question that we have that I would like to open to all the panelist members. Is there any good guidance on how to avoid these problems? the multiple problems that we have discussed till now? Is there any good guidance or way that they can be avoided?
Yes, there's a lot of guidance out there, but it's about the donor, as we say, which is the vulnerable person, receiving that guidance before they enter into the lasting power of attorney. And it is preferable, I think, for the person doing this to take some actual legal advice, or at least to take some go to an advice center or something and access that guidance. Obviously, it depends on the individual, because some individuals, although they may well have full mental capacity, don't have that opportunity. And it's about information and spreading information, which is one of the reasons why we were very keen to sign up as founder members to the lawyers panel with Hourglass, because a lot of these things can be prevented if the correct things are done at the correct time. For example, fraud and also abuse. The choosing of an attorney is actually something that does require quite a careful thought, because you have to think of all the potential scenarios and what that attorney might do in each scenario. But the answer is yes, but more information needs to be put out there, I think.
I mentioned earlier that the Office of the Public Guardian needs to be more proactive. One of the things I didn't say at the start was actually they were invited to attend today, but then declined, which is a real shame, because actually that would have been a good work question for them to answer what more could they could be doing to put out this guidance. Because I think we've heard that they tend to be quite slow. They do have a helpline, but they tend to signpost to other organizations. So I think that's the thing. I think there is the guidance out there, but actually they're an organization that should be stepping up a lot more in that space.
So one of the questions I think here is the extent to which the OPG is kind of held accountable for its performance. I mean, from time to time, there has been criticism of their performance about delays and slowness to act and the vulnerability of people in that situation. And again, thinking about the next year or so, is this a time where it would be prudent to put OPG performance under some scrutiny? Partly, actually, to see if one could persuade the government to give more support to OPG to perhaps develop its work.
Yeah, I think it could be worth a parliamentary question or two on that in the coming weeks. Yeah.
I mean, one thing I'm not sure is the extent to which OPG have been called to give evidence to a select committee at all in recent months or years about their performance. Some public bodies, do have very tough, even accountability reviews by select committees, which can be salutary for them.
Yes, I agree. I'd be very interested to know the statistics for the OPG's time to investigate potential abuse. I suspect it's very slow, and I suspect the outcomes are often not very satisfactory.
One of the benefits of a discussion like this is taking individual cases, which all of them sound very challenging, and seeing how we can improve the system.
Yes,
Thank you. Thank you, David. Thank you, Nick. Thank you, Lord Hunt. So we have another question from an anonymous participant following on the last case study that we discussed. What can we do if we believe a donor is being coercively controlled by an attorney when the donor still does have the capacity? Should we report it to the OPG? The donor has not disagreed when it has been suggested they are being abused, but absolutely does not want to address it.
Yes, this is a scenario we come across quite often, and I think one of the cases brought it out, in that particularly if you have a donor, the vulnerable person is living with someone, and they have and they're the main carer. There's a lot of the power dynamic there is very much in the attorney's favor on a day-to-day basis, and also in terms of control. Nevertheless, the OPG do have a duty to investigate, and they have an investigation section, and equally, social services have a duty towards vulnerable people, whether they have capacity or not, particularly if they've got some, if they're very elderly, that a safeguarding concern could be raised. So it's worth looking at that. In terms of unpicking what a donor might do, if there are transfers if there are lifetime transfers to someone else that are perhaps questionable, then there is a legal process for challenging them, and lifetime undue influence is a case where you can try and recover assets, and it's something that we do quite a lot. The difficulty is getting the evidence, and inevitably people will say it was a gift, it's what they wanted, and they might reference perhaps trying to avoid having to pay for care fees or saving inheritance tax, and people make gifts to avoid that, rightly or wrongly, and that's a whole nother issue really around deprivation of assets for care fees. But I mention it as it is something that sometimes can drive some of these transfers away from vulnerable people.
Thank you, David.
Could I just quickly add to that what you were saying about social services, and whilst on the helpline, we often suggest that people are contacting the safeguarding team at the local authority if they've got concerns. What we do find is people do have that mental capacity to make decisions around specific areas, like like the example that was given, and they will quite clearly say to the local authority they don't want any support. They're quite happy with the situation. We do find it is really difficult for safeguarding teams to intervene at that point. Rightly so, people are able to make decisions for themselves if they've got that mental capacity. But we do come across that quite regularly, where people have tried to get in touch with the safeguarding team, and they've kind of contacted the older person, and the older person has said, no, I'm absolutely fine, everything's fine. And it's just difficult for them to get involved at that point. But that doesn't mean to say that we don't, we wouldn't say to people, don't contact the safeguarding team. It's well worth getting in touch with them, even if it's just for a bit of advice on the situation.
Thank you, Lucy. Thank you, David. Another question we have is from Rob Anderson. It is deeply worrying that the recent reforms to modernize LPAs did not require some experienced and professional assessment of A, the intended donor's capacity, and B, the absence of I'm sorry, I'm not able to read that, pronounce it.
Coercion, I think.
Coercion. I believe this is still required for LPAs in Scotland. Does this panel think it is a realistic goal that at least people deemed as valuable in some way should require this higher level of certification?
I personally think that it is something that should be thought of very carefully. It is, as I said, a neighbour can certify someone as having capacity to enter into an LPA, and there's no real checks and balances around undue influence. Against that, though, there is the whole policy issue of wanting to make LPAs a very straightforward and quick and simple and cheap way of providing care and support to vulnerable people. So it's a balancing issue, and it's really one for policymakers. I obviously just see the abuse side, so I've got a kind of slightly tainted view of it. But on the other hand, it is a fact that there are hundreds of thousands of LPAs out there that work perfectly well and are very useful.
I mean, I guess the numbers on that are in 2020-2021, there were 5 million LPAs registered. in that same period, or in the year, I think it was April 2019 to October 2022, only 15 were actually removed from the register. So that's that, you know, you can see it is a minority. I mean, certainly in terms of our own cases, in 2021, we had 144 cases involving LPAs. Last year, we had 186. So that has increased. But, you know, you could still say, and I can imagine they would, you know, you would say that, you know, the majority of LPAs, there isn't abuse or there isn't coercion probably. And so you don't want to make it too cumbersome. What we do know is that where there has been coercion and there has been issues, often that there's been a lack of awareness. So that having some stronger safeguards in place when these have been taken out would help. So it's always a balancing act between, you don't make it so cumbersome for the, you know, 4.8 million that there's no problem, but you also want to make sure there's some safeguards where there's a problem.
I mean, the jury's out, isn't it? Still, really. Maybe we do have to see what incremental improvements we can make. Already we've had obviously some changes, and if the evidence becomes stronger that too many people are facing financial abuse, I would have thought there is then a stronger case for more extensive processes and potentially more legislation. I would have thought at the moment we have a watching brief as far as this is concerned. Because it's a good thing to celebrate success too, isn't it? And overall, my own judgment would be that the changes that have been made and simply the number of people who've been registered would suggest that overall this has been a very good development.
Thank you, Lord Hunt. Thank you, David. Thank you, Nick. Another question we have from an anonymous participant regarding the LPAs. With LPAs, are we always assuming the lack of capacity is the rationale behind doing the double LPA? What if a family has two siblings, one married and detached from parents, the other unmarried, who is the primary carer of the parents? The primary carer simply decides to make an LPA in order to protect their parent if they were to predecease their parent. Any tips or suggestions over here?
I think, sorry, I'll begin. I think from that question, I mean, they've said always assuming that there's a lack of capacity is the rationale behind doing the double LPA. As we've mentioned earlier on, the donor does have to have capacity to put an LPA in place. It's not possible for them to put one in place if they don't have capacity. And if they don't have capacity, then that's when a deputyship would be looked into. So yeah, that was the point that I wanted to make there.
Yes, I think I mean it may be that the main carer themselves wants to enter into an LPA in case the main carer has an issue where they lack capacity, but certainly you do need capacity for both, and most LPAs are obviously entered into with a view that someone will lack capacity in the near future, or there's a possibility. I hope that's helpful.
Thank you, David. Thank you, Kimberly. Next question we have is from Trevor Greenridge. If a resident in a care home lacks the capacity to give consent to their LPA for finance, access their care home notes, personal care information, can the POA challenge be challenged by arguing and then gaining access to the notes by pointing to their duty to ensure they are acting in the donor's best interest?
Well, I assume here that the resident did have capacity and entered into an LPA, and that the attorney is then looking to intervene in their care. And that certainly an attorney should have access, especially if you've got a health and welfare attorneyship, should have access to their to the local authority and care home records. The care home in that situation should also ensure that a deprivation of liberty application is made, and social services could be involved if there is some problem with the care home. But I hope that's helpful.
Thank you, David. Another question we have is from Mark Stewart. Is there an aspect where LPA can only be done when a person is in capacity versus deputyship, which can be once the person lacks capacity?
Yes, a deputyship can only be taken once someone lacks capacity, which is the principal difference between the two. So the answer is simply that it is only once someone has lacked capacity that a deputyship can be entered into. If there's already an attorneyship in place, then obviously you don't need a deputyship because that will suffice.
Thank you, David. Another question we have from an anonymous participant is, should everyone making a will also complete an LPA at the same time?
Oh, sorry. Did you want to go? I'll take this one first. Yeah, so they both have very different functions. An LPA is in place during the lifetime of the donor, and it is only valid for the duration of the donor's life. And when they pass away, it ends on their death. Whereas with the will, that comes into place on the person's death. So they have two very different, you know, reasons for being in place. And yeah, definitely I would suggest that if someone's thinking about putting a will in place, they should definitely think about putting an LPA in place.
Thank you, Kimberly.
Can I just ask you, Kimberly, on that? I mean, I've just in recent years persuaded all my children to make wills. Would you suggest people in their 20s do this?
Yes, definitely.
You would you? No, that's interesting, right?
And LPAs as well. I think LPAs are very important. In some ways they're more important than a will because, you know, it's helping you during your lifetime, whereas in some ways a will is more for your family or, you know, whoever it is that you're leaving your possessions to. So yeah, I mean, regardless of age, I think it's important. I mean, you can obviously only put an LPA in place if you're over the age of 18. But yeah, I would definitely suggest that someone in their 20s, 30s, you know, should put a will and an LPA in place.
Thanks.
I guess just to add to that as well, just kind of going back to my advocacy days, we would work with a number of people that when they didn't have LPAs in place, and then they would lose capacity to make decisions around finances or, you know, where they're going to live, you know, kind of important health and welfare decisions. And what a lot of family members didn't realize really was that that's when the local authority stands in and, you know, ultimately make decisions on behalf of people. You know, where they're going to live, what care home they're going to live in, and they will, of course, you know, there's an expectation that they do speak to the family and you know, take into their views and wishes. But ultimately, you know, it's a social worker's decision to make where somebody will decide to live. You know, that could be your mum. You know, if there's no LPA in place, it's, you know, it's essentially a social worker that's making the ultimate decision. And you know, that's a difficult situation that a lot of families find themselves in and aren't really aware of. A lot of people kind of think, you know, this idea that you're the next of kin and that has some type of legal standing, and, you know, obviously it doesn't. So no, it's so, you know, just like I say, going back from, you know, working as an advocate in that area, it's just so important to consider an LPA. It really is.
Thank you.
Thank you. I would like to just, you know, we have time for just one more question. So the last question for today's webinar is that if the LPA from an anonymous participant, if the LPA is more helpful Is there a way in which there can be professional attorneys, especially for those with no families or close friends?
Yes. Can I take this? Yeah. Yes, I'm a professional attorney for 2 or 3 people, I think. They're less common, but it is something that can be done. Obviously, a professional attorney within the lasting power of attorney deed itself, there's provision that they can take their fees. And if you were going to do that, which there's something to be said for it. If you were going to do that, you'd want to have a very careful conversation with them about how much they're going to charge. And unlike a deputyship, an attorney, they can charge. They do not have their fees assessed by the court. So you might want to put into the deed that there's some sort of way of some mechanism of their fees being regulated and checked and made sure they're reasonable, because obviously if you're granting that attorneyship, you may well not have the capacity to do that yourself. So it is something that you can do. Normal attorneys cannot charge at all for their costs, although they can take their expenses. But a professional attorney will charge. And there's some advantage in that if you have in the lasting power of attorney, you are choosing your attorney, and you have perhaps a relationship with that attorney, and you perhaps have some understanding about what they're going to do with their fees, and that they understand you and your wishes. So there is some advantage to that. There's also an advantage to having a professional attorney sometimes as a replacement attorney. If the main attorney, for example, in our first scenario, decides to revoke, to renounce, you don't then have a period where no one's in charge, as you would in our first scenario, which can be very problematic, particularly if you're in a moment of crisis. You do need someone to be able to step in quickly and perhaps chase the fraudster for the money or something like that. So you can do that, but as I said, do be wary about fees, and do choose carefully all your attorneys, whether they're professional or not, because you're giving them a lot of responsibility and a lot of power. So do be careful.
Thank you, David. Thank you all the panelist members. I hope have any of the panel made a will plus an LPA for themselves?
Yes,
it's on my list.
It's also on my list.
I've done mine. But then I'm of an age when you definitely need to have done it.
No, I did mine years ago.
I put it all in the hands of my 5 children. They'll need a committee.
Oh no.
or Kimberly or David.
We're always happy to help.
Thank you.
I would once again like to thank all the participants and the panelists for giving us your valuable time. Would also like to mention again that after the webinar, you'll receive a very short survey via SurveyMonkey. So I would request you, all the participants, to please complete the survey. We highly value your feedback. So please take a moment to share your thoughts. Your inputs would help us improve and tailor future events to your needs. Thank you so much once again to Anthony Gold, David and Kimberly, Lord Hunt, and Nick and Lucy for your time today.
Thank you very much.
Thank you.
Thank you.
Thank you.